Good morning, everybody. Thank you all for joining us. We're going to give everybody a minute to get in from the waiting room here. Almost there. All right, I think that's most of us. So I'm going to start like I usually do with our Zoom housekeeping tips. Again, we're happy to have you here with us today. And one of the things that we ask everybody to do during these Q&As is to stay muted. And if you don't know where your mute button is, your toolbar might be flashing, your Zoom toolbar, because I just put a message into the chat. And on that toolbar, you'll find your audio button, your video button. That's where you can mute or unmute, as well as start and stop your video. That's also where you'll find, like I said, that chat button. And the message that I just put into the chat tells you about how to submit questions to the Q&A. So if we don't happen to get to your question today, you can email it to info@condolaw.net by 4 p.m. on Monday, or if you think of another question between now and then to add to our list. The chat message also includes a link to our YouTube channel, which has all 5 years of videos that we've been doing this Q&A, and it is searchable by topic. So unless you're searching for a really common topic like, I don't know, condo or assessments or something, the search function within our YouTube channel can be a really useful way to look up videos that are relevant to whatever topic it is that you're trying to research. So aside from staying muted, of course, you're welcome to unmute yourself if you would like to ask a question verbally during the Q&A. But otherwise, if you put your questions into the chat, that's also a good place to ask us to clarify something that we've said during the Q&A if you're confused or you want us to have more information about a question that we're answering. And I am very happy to see a couple questions already in the chat, because one of the things that we were going to tell you today is that we had a whopping 3 questions submitted in advance for the Q&A today. So we will definitely have time to get to a handful of questions from the chat if you put them in there. Moving along through our announcements, I will remind you that we are here not to give legal advice, but just to talk generally about legal information that we think is helpful for community associations in Washington State. So if your question is really specific to your community or a set of facts or a set of documents, we're not going to be able to answer it, but we will do our best to cover the topic generally. I also want to remind everybody, as we've been doing for a number of weeks now, about WSCAI's Monday Morning Minute email. And I'm going to put the link for that into the chat. This is an effort of our Legislative Action Committee through Washington State Community Associations Institute. But sidebar, Chelsea does not work for them and has no power to sign you up for the Monday Morning Minute or help you troubleshoot why you're not getting the Monday Morning Minute emails. So if you are struggling to get those emails, follow the link. You can contact WSCAI if you need to. One thing that might be happening is that you have to sign up again every year. So every year, the people who sign up for the Monday Morning Minute, that list gets purged at the end of the legislative session. And so you have to sign up for the Monday Morning Minute every year if you want to keep receiving it. But Chelsea cannot help you troubleshoot any issues with your access to that email newsletter, because we don't run that thing. That is WSCAI. So keep that in mind. And do consider signing up. We've had a handful of calls to action go out via the Monday Morning Minute in the last several weeks. The most recent one had to do with House Bill 1443, which proposes to require that owners of lots, all lots, not just within an HOA, but lots, be allowed to put a mobile dwelling on their lot. And the way that this would play out in a community association is if your documents already prohibit multiple dwellings on one lot, then those documents would still be enforceable. But unless your documents specifically prohibit that, the bill would ultimately have the effect of requiring that HOAs allow people to park mobile dwellings on their lots. So there's a whole lot of reasons why we oppose the bill as it's currently drafted. The Monday Morning Minute, if you had been subscribed to that, would have told you about the bill. And there was a call to action in the Monday Morning Minute email this week asking folks to contact their legislators about this. So if this is something that you care about, A, sign up for the Monday Morning Minute, B, Google HB 1443 and consider contacting your legislator and asking them to vote against this bill. The CTA update that we gave you guys last week is the same. So the Treasury Department has announced that it's not going to enforce the CTA against domestic companies. However, the CTA's reporting requirements are still a part of the statute as it was enacted by Congress. And I think there's some question as to whether the Treasury Department has the legal authority to just ignore a duly authorized statute passed by Congress. So the risk right now of not complying with the CTA's reporting requirements is quite low. But until the law itself is changed or eliminated, the lowest risk approach is to go ahead and comply with it anyways. So you're welcome to put any questions that you have about that into the chat, but that's the position that we're still taking here. Another announcement is that on April 24th through 26th, the WSCAI annual conference is taking place. We will be there. We have a booth. We have attorneys that are going to be speaking on a couple of different topics, including WCAI for All. I just put a link to that event in the chat. And so we hope that some of you will consider joining us. And if you do, please come say hi at the booth. Chelsea will be there, and a number of the attorneys from the firm will be there throughout the couple of days that we're attending. And I think that might be it for my announcements today. I'm just double checking to make sure I didn't miss anything, and I don't think that I did. So I think, Lisa, you can go ahead and take it away with our first question.
Sounds good. Good morning, everyone. The first question is, if an owner is over 1 year late on paying HOA dues, what recourse can be taken by the board? Could we collect if they sell the unit? And the short answer to this is, what recourse can be taken is you can probably record a lien. And the short answer is, yeah, you probably could recover if they sell the unit. But there are a lot of variables here, and you definitely want to consult with your legal counsel on this, because there may be situations within your governing documents, within whatever statute you're organized under. We don't know what the organizing statute of the person who asked the question is. And so there may be, for example, Ken wanted us to remind people that the HOA Act, for example, doesn't contain authorization for recording a lien unless your governing documents do. So if you're a homeowners association organized under 6438, you may or may not have a right to record a lien, depending on what your governing documents say. The other statutes pretty much authorize or either create a statutory lien or authorize the recording of a lien, dependent on the situation. But there may be other factors at play. How old is this debt? There is a statute of limitations depending on what kind of statute you're organized under. So it could be 3 years, it could be 6 years, between how long it has been since the person paid, whether or not those funds are still collectible, and whether you would be legally able to record a lien or to attempt to collect that debt. You really should talk to someone about this, and generally our position is talk to your attorney as soon as possible. Follow your collection policy if you have it, or your rules if that contains a collection policy, your other governing documents as to timelines and notices and things like that to your owners who aren't making payments. But the sooner you get your attorney involved, the better. We've had situations, I had some just recently, where the associations had to write off several $1,000s worth of otherwise collectible debt because they waited too long, and the statute of limitations affected the collectability of some of those funds that were legitimately due to them. So really get on these quickly. If you're an annual assessment type of situation, sometimes that's a whole year might pass, but before if the person is actually still delinquent. If you're on a monthly thing, a couple months, really get somebody involved, because you really want to make sure that you're able to collect what you're owed. We talked before, and as Valerie mentioned, we don't have a ton of questions today, so we thought this might be a good place, unless Valerie has other comments on this question, to kind of give you a general outline of the collections process, at least as we handle it in our firm. You're lucky enough, both Valerie and I are in the collections department primarily, so we do this all the time, and we would love to give you a little insight on what attorneys need and what the steps are to go about collecting on overdue assessments. Valerie, do you want to kick it off?
Yeah, I'm happy to do that. And one thing I want to say is that I think a lot of times boards move more slowly with delinquencies out of compassion for the owners because it feels kind of crappy to move the collection process forward and add additional costs to what they owe when they're already struggling to pay. And so I know that this is a difficult decision, and I know this seems counterintuitive, but the sooner you get the debt to your law firm, the more likely it is that they will be able to collect the balance due from the homeowner without going through the litigation process, which is the most expensive way of collecting unpaid assessments. So I know that if you're looking at a debt that's maybe $1,000 or $1,200 and the cost of sending a demand letter is $500 or whatever it is, that feels like, well, God, I'm increasing their debt by 50% just by getting the attorney involved. And I also know that it sounds self-serving for me to say this, and you guys, the only thing that I can tell you is this is 16 years of experience talking, and demand letters is not where we make our money, I guess. Let me just say that. Avoiding litigation, if I were practicing law in a way that was self-serving and profitable for me, I would want to litigate every case because that is profitable for law firms. But what is most effective in terms of allowing owners to have some chance of actually catching up on the debt is for it to still be relatively small when they get that letter from the law firm. And if you can imagine for a minute that maybe you have been through this, I know I certainly have been through times of financial hardship in my life where every letter in the mail is somebody that wants money from me, and I'm robbing Peter to pay Paul and sort of just always falling short every month. If you get a letter in the mail from a law firm that says you owe your HOA $1,500, or you get a letter in the mail that says you owe your HOA $10,000, which of those is going to feel like something you can actually manage to catch up on and maybe have some hope of paying, right? So as counterintuitive as it may seem and feel, the sooner you start the legal process, the more likely you are to have a hope that the owner will be able to pay what they owe without you having to go through the litigation process to achieve that end result. So with that said, I'm going to start talking generally about what you all need to know before you send an account to your association attorney. So, I mean, first of all, you need to have a relationship with an association attorney. And we talked a little bit last week about how you choose one if you don't have one already. And I beat this drum occasionally because I think it's really important for you to establish that relationship before you actually really need it. And some of the other things that you need to know include, have you read your governing documents? So one of the things that Lisa mentioned when she was answering the question just now is the HOA Act does not have a statutory lien right. So if you're a community that's governed by RCW 6438 and you're a single family home HOA under that act, you only have the right to record a lien if your governing documents say that you have the right to record a lien. And we actually had a client recently that came to us for some liens with unpaid assessments within their community. And their documents were really quirky because their documents said that the association had the authority to enforce a lien, but the documents did not say that they had the right to record a lien. So one sidebar that I guess I will offer here is that's one really strong argument in favor of adopting WSCAI early. If you are in an HOA Act community and your governing documents do not provide the authority to record a lien for unpaid assessments, that means you can't record a lien for unpaid assessments, where if you adopt WSCAI as your governing statute, you have a statutory lien right, and the fact that it's not in your governing documents isn't fatal to your ability to record that lien. So that's one thing you could consider if you're a community that's wondering, like, should we adopt WSCAI early? Should we wait until 2028 when it's automatic? That's something to consider. Knowing what statute your community is organized under is also really helpful. And one of the reasons it's helpful is because this dictates what your statute of limitations is. So we have 4 common interest statutes in Washington right now. We have the HOA Act for single family homes that were formed, single family home communities formed before WSCAI was enacted. We have the old Condo Act, the Horizontal Property Regimes Act, which is for condominiums formed before July 1st of 1990. Then we have the new Condo Act, which is for condominiums formed from July 1st, 1990 until WCAI was enacted. And then we have WCAI, which is for all community types formed July 1st, 2018 forward, or any community that might have chosen to opt into that statute. So the reason that your governing statute matters beyond just the lien right issue that we were talking about is the statute of limitations. Under the HOA Act and under WCAI, your statute of limitations for collecting unpaid assessments is 6 years. If you're under either of the condominium statutes, your statute of limitations for collecting unpaid assessments is 3 years. And if you don't know what a statute of limitations is, it's basically a time limit during which you have to file a lawsuit. Otherwise, you lose the right to collect older amounts due that are outside of that window, whether it's 3 years or 6 years. But again, I'm going to encourage you, don't ever wait until it's 3 years or 6 years, no matter how large or small the debt is, because the longer you wait and the larger the debt is, the less likely the owner is to be able to pay in full. Lisa, did you want to go from there?
Sure. Following up with what Valerie just said, the attorney's going to want, when you decide, okay, this person is delinquent, this unit owner is delinquent, this lot owner is delinquent, I'm going to send it to my attorney for collections. What does your attorney need from you? And this is something that is helpful to know, because getting your files in order or keeping them in order before you need them is very helpful for everyone involved, and it cuts down on some of the back and forth and some of the frustration on both sides, I think, that can occur. And so piggybacking on what Valerie said, one of the things, all your governing documents. So if you have a relationship with your attorney, hopefully they already have all this information, but we need all the stuff you've got. We need your declaration, we need your bylaws, we need your rules, regulations, collection policies, any board policy decisions on late fees, whatever it is you've got that deals with potential collection action. That's definitely something we're on the collection side are going to want. And again, if you already have a relationship with an attorney, they likely have all that stuff. But that is a good reminder that if you change something, even if you have a relationship with an attorney, send them that new document. If you've updated something, some policy, some procedure, some rule, keep your attorney in the loop on that if you've done it without their assistance. We will always need an account ledger, and we will say a zero balance ledger from our end. And what that means is we need all of the entries on your account for that owner going back to when there was a zero balance. An open statement we see sometimes, which is just sort of like an Excel spreadsheet with a list of stuff on it, really isn't what we're looking for. What we need is every entry, every payment as they go through, starting from when the owner was at a zero balance. And that may have been several years ago, even if they only started becoming delinquent in your eyes. We need to go all the way back so we can see what charges were made on their account. We need to know who this person is or this entity is, their name, their legal name, and their address. If they've given you another address that is other than the unit or lot, we do need that. A lot of you know that in your governing documents, it'll say, notice needs to be sent to, the statutes say the same thing, the owner at the unit or the address they've given to the board. So if they've given you a different mailing address, make sure you give that to your attorney as well. And I do want to note that oftentimes, if associations change management companies, sometimes that information gets lost. That is definitely something to highlight. I don't know if your system can retain that information, having two separate addresses, but that's really critical to have, because you want to make sure that the information that we have is the best way to get a hold of that owner, and that you've been notifying them at the correct address. Sometimes you might hear from us that says, hey, you need to send them another letter because you actually had another address for them, and that wasn't something you sent to. So make sure we get that information. And as obviously, if the property address is different from the address where you communicate with the owner, we'll need that. If you have their email and phone number, those are critical pieces of information for us. These days, especially, owners really are happy to email. And so that seems a less painful way of communicating with someone about something that's pretty personal. So an email address is critical for us to communicate with people if we can. If you know who lives in the property, that is extremely important information. Is the owner live there? Are they renting it out? Is it vacant? What's the status? And then if you've communicated with that owner in some way, all the notices you've sent them telling them that they're delinquent, and in particular, if you have emails or any communication logs with that owner, we would love to see that too, because sometimes there may be something you've missed or something that is really critical for us to know before we get started with sending a demand letter. And also we want to make sure you followed your collection policy and your rules by sending the appropriate notices to them. And then finally, well, there's two more final things. If there are fines or compliance violations on this person's ledger, we're going to need to see all the notices that were sent to them, informing them the warnings and all the process. We've talked at length in other Q&As about due process and what needs to happen in order to levy a fine against someone's account, but we will want to see all of that to back up the fines that are on there. And then finally, you probably, if you're one of our clients, have heard us ask for your budget documents, your annual budget documents. And this seems crazy to you probably, but we have also talked about this at length, that WSCAI has pretty strict requirements about what makes a budget process compliant. And we'll talk about this in a little bit, are governed by some federal collection laws. And we need to make sure that the debt that we're collecting is valid, that it has been validated. And one of those things is verifying that your budget process was in compliance with the statute. So we will want to see the packet, the notice that you sent out to your owners in anticipation of the budget ratification meeting. And then we'll talk to you more about that when we get that, but that is definitely information we need. Anything I missed, Valerie, or you want to go on the next?
No, I don't think there's anything that you missed.
Okay.
So we'll keep moving through the topic because I see that we do have a good number of questions in the chat as well now. So the next question or topic that we want to cover is essentially what the options are for collecting a debt. And I won't beat a dead horse and repeat what we said about the lien being an option, except for HOA communities without that right in their documents, HOA Act communities. So the first thing that we do when we get a file typically is we send the owner a demand letter because we want to make sure that we're notifying them of the balance that's due. We also have to comply, and Lisa will talk with this a little bit later, with the Fair Debt Collection Practices Act, which is a federal statute that says when a third party tries to collect a debt on your association's behalf, we have to follow certain rules and how we communicate with the owners. We often, but not always, record a lien at the same time that we send the demand letter. The reason that we say not always is because it's really expensive anymore to record a lien. And I'm not even talking about the legal fees, which for us have remained relatively affordable, but county recording fees are now over $300 per document. And so every time we record a lien, we're not just thinking about the cost of the lien, but we're also thinking about the cost of the lien release. And you're talking about just the cost of the lien and the release, including those $600 and some dollars in recording fees, is pushing $1,000. So if the debt comes to us and it's under, $1,500 or $2,000, we'll often recommend starting with a demand only, hoping that the owner will respond. We can get them on a payment plan or get them paid in full within a few months and avoid that lien cost. On the other hand, we do always consider that for HOA communities under the HOA Act, you also don't have any statutory lien priority. So if it's a balance due of only $1,200 or $1,500, but you're in a single family home HOA community under the HOA Act, and it's 3 years of assessments that haven't been paid, we're looking at the possibility of getting that lien recorded earlier, because for HOA Act communities, again, you don't have statutory lien priority like condominiums and WSCAI communities do. So getting it recorded earlier matters more for HOA Act communities than it does for anybody else. We also, after we send that demand letter, whenever we have contact information available to us, we will try to email or call the owner to follow up, because for two reasons. Number one, like I said earlier, if you're in financial trouble, you are often not reading your mail, because everybody who is sending you a letter in the mail is because they want money from you and you don't have money. And so you're ignoring it all. And so we feel like reaching out and actually making personal contact with people, either by phone or by email, increases the chances that we'll get a response from them. The other thing that is a less sympathetic reality is that a lot of people tell us when we get involved in collecting a debt and then we call or we email and they'll be like, well, why didn't the association tell me? And we say, they sent you 6 notices of delinquency in the mail and you never responded. They'll say, well, I don't read my mail. I don't read my mail. A lot of people just don't read their mail anymore. And not even just those who are in financial trouble. So making personal contact by phone or email increases the chances of getting a payment plan in place or otherwise resolving the balance due without having to escalate it through the rest of the legal process. Depending on what your documents say, we might be able to add a security deposit to what they owe or accelerate a year of assessments and add that to what they owe. But again, that's very governing document dependent. And if we send the letters and we try the emails and we make the phone calls and the owner is just not responsive to every effort to communicate with them, you might be left with the question of whether to file some kind of lawsuit. And there are a couple of options when it comes to lawsuits. The most sort of versatile, or the one that has the most additional follow-up options included with it, is a foreclosure lawsuit. There are statutory thresholds that have to be met before you can file a foreclosure lawsuit, and also timelines that you have to follow. So this is something you have to evaluate very specifically on a case-by-case basis. The statutes also require that the board specifically authorize each foreclosure individually. So I had a client years ago that they voted as a board to have a sort of like a template, a process that we followed with every account that was referred to our office. If there was no response and this much time had passed and the balance due was more than this dollar amount, they automatically wanted us to proceed with a foreclosure lawsuit. Now that the statutes have these thresholds and these specific voting requirements, you can't do that anymore. Once we file a foreclosure lawsuit, that does not automatically mean we're going to do a foreclosure auction. That is one of the options. A sheriff sale is one of the follow-up options once you obtain a judgment in a foreclosure lawsuit. But we also, with a judgment, can try to garnish their wages or their bank accounts. Sometimes people really do just ignore everything until they're faced with something that they can't ignore, like a garnishment or maybe a sheriff sale. If the property is not owner occupied, once you file a foreclosure lawsuit, you can also ask the court to appoint a custodial receiver to take possession of the property and either divert rental income if it's tenant occupied, or get it fixed up and rent it out if it's vacant, so that that rental income can be applied against the balance due and can offset the growing delinquency. For old act condos only, if you have it in your documents, utility termination is also an option in certain circumstances. What I will say about utility termination is that I would strongly advise you never to do this without specifically consulting with your association attorney, not just because there is a process that has to be followed, 10 days notice that have to be given, etc., but also because utility termination, just like any other action that the association takes, must be reasonable under the circumstances. And if there are circumstances that make it unreasonable, such as somebody with significant health problems living in the unit, somebody that has some sort of like assistive living device that needs electricity, freezing temperatures that would either be bad for the owner's health and or risk the integrity of the building, like pipes freezing, things like that. There's a lot of different reasons why utility termination might be unreasonable, and your board should only be making that decision with the advice of counsel, in my opinion. The other type of lawsuit that you can file is a personal lawsuit, and we can do this for you in like Superior Court or District Court, and you as a board can do it in small claims court without having to hire an attorney for that part. The reason that you might want to consider that is if you're dealing with a smaller debt, there's a jurisdictional limit in small claims court anyways. A corporation like a community association is limited to obtaining a judgment of no more than $5,000 in small claims court anyways. And if the balance due is, $1,500 or $2,000, often it feels really punitive and maybe potentially unreasonable to pay a law firm $2,000 to file a lawsuit against the owner, but you can take that case to small claims court and get a judgment against the owner And then you would have the same personal judgment options, including garnishment, as you would if you had your law firm be the one to file the judgment. So let's see here. Payment, we covered the payment plan option. I think I did anyways, but if I didn't, I should. If we get an account in our office and we send a letter to the owner and they contact us and they say, I can't pay this $3,700 all at one time. Can I pay $500 a month until I'm paid in full? We are very payment plan positive. Like we encourage them. We often encourage our clients to consider waiving late fees and interest if an owner is otherwise willing to pay the balance due. The whole point of having us get involved is to help you bring that owner current. And refusing to accept payment plans, I think, unless there is a reasonable basis for it, a refusal to accept a payment plan could be viewed by a judge as unreasonable later on if the case ends up in litigation, right? So if your attorney is telling you that you really should consider this payment plan, there's usually a good reason for that. On the other hand, if you have really good information as to why you don't want a payment plan from a particular owner because of a long history of defaults or whatever, you need to make that known to your association attorney so they can advise you accordingly. Rent interception, if it's in your documents, you can send them a rent intercept letter. We can't do it. We can't contact third parties, including a tenant, about a unit owner's debt without the unit owner's permission. But we can prepare a rent intercept letter for you to send to the tenants, telling them, hey, look, our governing documents say that you have to pay us the rent instead of the owner. What I will tell you is that as a practical matter, they fail 95% of the time because the tenants don't want to get in the middle. They're afraid that if they stop paying rent to the landlord and start paying it to the association, that they're going to get evicted. Sometimes tenants will just move out rather than deal with the conflict between the unit owner and the association. So they're a great idea in theory. It's a relatively low cost option to try. So I always feel like it doesn't hurt, but they're not very effective. The last thing that I want to cover briefly is that you should be aware that a lot of governing documents, a lot of declarations will have alternative dispute resolution provisions within them that require certain types of disputes or all disputes between associations and homeowners to be subject to mandatory mediation or arbitration. Often, and if they're well drafted, they will contain a specific exception for collection of unpaid assessments. In other words, it might say that anytime there's a dispute between the association and the homeowners, everything has to go to binding arbitration, except for if the dispute is about unpaid assessments, and then the provisions of the collection section will control, okay? But now and then we see them, and it's not uncommon. It's not as a tiny minority of the time. It's like probably at least 25% of the time. We'll see them where they don't contain that specific exception. And what that does is it sets up an internal conflict within the declaration where you have one section that specifically says you can file a foreclosure lawsuit if an owner stops paying, but then you have another section that specifically says all disputes are subject to binding arbitration. So you should be aware of that potential conflict within your documents. Generally, the way it works is that is it's a defense to a lawsuit that an owner can raise once one is filed. But there is some risk. We have not seen it play out this way in court yet, but there is certainly some risk that a judge might say, you never should have filed this lawsuit to begin with because of the ADR provision, and we're going to toss the case, and you're not going to get, you're not going to get your ability to recover the legal fees from the homeowner. So, so just be aware of that ADR provision. If your attorney doesn't flag it for you, you should ask them about it to make sure that they're aware of it and are mindful of what those consequences could be. I do see there are a couple of follow-up questions in the chat that I think are worth covering. One is, should the HOA call the owner first in addition to the notices before hiring an attorney? I love that idea. If you have the capacity, call them and email them. A lot of times people are just not reading their mail, or they're thinking, oh, it's come from the HOA or it's come from the management company. It must be this notice or that note. They're assuming they know what it is. They're not reading the mail. And if you call or email them, that might result in voluntary payment or voluntary payment plan that could allow you to avoid the legal fees. So I think it's a great idea if you're willing to do it. I do think, this is a lot easier in a 12-unit condo than it is in a 3,000 home HOA, right? Because the sort of the administrative burden created by the numbers game is really different. But I think it's a great idea. The next question that's in the chat says, once all of the balance in the delinquency is paid and it includes a security deposit, how long does it stay on the homeowner's account? And does the association refund it back to them after that time? I'll say this is governing document specific. Number one, some governing documents specifically say that the security deposit is held to the credit of the unit or the account, and there is no requirement to refund. Sometimes it specifically does require that it be refunded, but also it's very case or fact specific. A lot of times when we negotiate a payment plan with a homeowner, we will negotiate a specific time frame, and it'll say something like, once you pay on time for 24 consecutive months, then you get the security deposit refunded to you. So I can't answer this question definitively for every circumstance. What I will do is point you both to the security deposit provision of your governing documents and to any agreement that your attorney has negotiated or that you might have negotiated with the homeowner when they paid it. I don't know if you have anything you want to add, Lisa, or just keep us moving here.
No, I'll just do a quick conversation about what Valerie alluded to before with the Fair Debt Collection Practices Act. You might have heard us bandy the FDCPA, or you might have heard it around. It applies not just to the collection of community association assessments, it applies to collections writ large. But for our purposes, we're going to talk about it in reference to our collection of your community assessments. And that is sort of a key distinction. The people that you hire to collect assessments on your behalf, you as the board or as the association, are the ones that are subject to the Fair Debt Collection Practices Act, not you as the association yourselves. So letters that you send, that your management company sends on your behalf, communications that you have with owners are typically not something that you don't typically need to be concerned with complying with the Fair Debt Collection Practices Act. But we, as debt collectors in this situation, do. And what this law is, generally speaking, is a federal statute that basically restricts how and when and why sometimes we communicate with folks to collect money from them. And this could be as simple as not calling them between 8 a.m. or not calling them before 8 a.m. or after 8 p.m. at night. It might be as simple as certain time frames for them to respond and object to the debt or request a validation of the debt. It just generally governs the interactions that we have with an owner when we're trying to collect their debt. The repercussions are real. So if we fail to comply with the statute, we as the debt collector can be sued and or fined. So we are very keen to comply. And this goes back to what I was saying before. One of the main things it does is before a debt collector can send a communication to someone who owes money to their client, we need to validate that debt. We need to say, yes, legally, the association has a right to collect this money. And the way we do that is by looking through all your account statements, by reviewing your budget, by reviewing your governing documents, and making sure that the money that is owed to you as the association. So you may find sometimes your attorney says, hey, I can't collect X, Y, or Z on your ledger, and this is why. Or as Valerie talked about the statute of limitations, we can't include amounts prior to this date on your on the letter we're sending to the owner, or we can't include that in the lien. So we're very conscientious about that. It also comes up often when you send the referral to our office, but we haven't done anything yet because we're still collecting information, because we're still compiling the ledgers and creating our ledgers internally. And the owner calls you and says, hey, I want to pay. And you say, hey, that's what the attorney called them. We can't actually speak to that owner until we've actually sent that demand letter. There are some grayer areas, but that's essentially the situation. Once that demand letter has been sent, we can then have a phone call with the owner if they call us, or an email if they email us. But we can't do it prior to that point. So sometimes I'll encourage an association, if the owner has called you and before it's come to, before I've sent anything out, you might be able to get this resolved so that, you might be able to save yourself a little time and money, but we cannot communicate with that person until we've validated the debt and sent that demand letter. And one of the other things that comes up in relation to the Fair Debt Collection Practices Act is what is called Regulation F. And that is a subset of the act that basically also governs email communication with an owner. And it seems kooky, but if you're one of our clients, one of our collections clients, you will get an email from us that says, here's something we need you to do. You need to email the owner first and tell them that the matter has been referred to our office, and give the owner 35 days to say, I don't want Valerie or Lisa to email me. If they don't say that, then we can email them, but not before. And this seems wacky, but we, again, do not want to violate the statute, and we do not want to be subject to a lawsuit or fines or anything else. So we are very careful and cautious about this. So we will send you an email, say, hey, send this email, we'll give you the text, send it to the owner, give them a chance to tell you they do or do not want to be contacted by us. And then after that time period has passed, we can contact them, assuming they haven't opted out. If the owner on their own gets my demand letter and sees my email and emails me, then I can certainly respond to them. I do have limits, again, on how many times a week I can respond to them or how quickly I can respond to them, but that's something that we need to be conscious of on our end, not necessarily to go into detail here. But the key to know is we can't just reach out to somebody by email before you've given them an opportunity. You as the creditor have given them an opportunity to object. And if you do get that objection, we need to know about it right away. There have been, I'm going to say in the past, I think that we've been doing this for about 3 years, 3.5 years, maybe a little bit longer. Since that time, I think I've only had maybe less than 5 people opt out of email communication, but it could happen. And if they do, then we do need to know that. I think that's probably it. Valerie, anything to add on the FDCPA? Basically, just know that if we're asking for something, we really need it because we don't want to be in violation of the statute.
Yeah, I think a couple of other things that I would say include the fact that if somebody sues us for violating the FDCPA, they're almost certainly going to sue the association as well, because they're looking to bring in as many deep pockets as they think exist to recover whatever damages they think that they're owed. So part of why we are so careful, of course, is because it's protective and it's self-interested on the part of the law firm. But part of why we care so much is because we understand that if we walk around violating the FDCPA, we're not just exposing ourselves to liability, we're exposing our clients to liability as well. The other thing that I will point out is part of the debt validation process includes things like figuring out if you have the authority to charge that repair cost to the unit that showed up on the ledger, 18 months ago, before an account was sent to our office. I cannot tell you the number of times we have had an account referred to us where the owner is paying all the monthly charges and the only delinquency stems from some charge, 18 months ago, plus 18 months worth of late fees and admin fees and other charges, only to then have me turn around and tell the client or the management company, this is not authorized by the governing documents. It's not collectible. I can't send a demand letter trying to collect it. You need to reverse it and write off everything that's on the ledger. So one thing that I would also say as a related recommendation is when you're thinking about charging a cost like that to a unit owner or to a homeowner, check with your association attorney before you do it and make sure that not only do you have the authority to charge that cost to them, but that you're following whatever process is outlined by your governing documents in order to do that. A lot of documents will say that you can assess certain types of costs to the unit owner, but will require due process, notice, and an opportunity to be heard before you can charge that cost to the unit owner. And it would really suck if it came to me a year and a half later and I had to tell you that you couldn't collect that charge from 18 months ago, not because you didn't have the authority to collect the charge, but because you didn't do the thing right. You didn't follow the process correctly, right? So those are just my only other couple of notes on that subject. So let's go ahead and move through. We have 2 other questions that came to us in advance, and then we have a bunch in the chat, and we'll try our best to get to them.
Sounds good. Okay, next question. So off the collections topic entirely. Do all motions need to be stated in the agenda for a special meeting of the board? And the short answer to this question is probably. I mean, your agenda should reflect the matters that are going to be discussed at your board meeting, the one that, the agenda that's sent out with the notice of the meeting to your members. But, I think the question is, what's the risk here? What are you talking about, basically? Is this a topic that is, something small, something you need to do, the landscaping needs to be changed, or you're talking about a budget ratification or a special assessment ratification or special assessment discussion? And to kind of figure out how high the risk is or how low the risk is, we want to look at the governing statutes for community associations. All of the governing statutes do indicate that the notice of the meeting should include an agenda. But failing to provide the agenda, with the notice may or may not be an issue. If you're sending the notice out, you've got the topics on there that you think at the time you send the notice are the topics that are going to be discussed, but maybe you tell the owners the agenda may be updated as the meeting time gets closer. Look on our website on this day before the meeting happens. That probably is appropriate, and that's probably enough to tell folks. But the idea is just that you're not keeping your owners in the dark. Make sure that they are aware of the potential topics that are going to come up at the meeting. But if something comes up at the meeting that was not on the agenda, it doesn't mean you can't talk about it. It doesn't mean you failed to properly notify your owners. But just keep in mind that, the goal is not to hide things from owners. So if this is coming from a place of we don't want people to know what we're talking about, I have a different response for that kind of a question. But if the question is, what if we made a mistake? What if it was something small that came up that we had to talk about? I think you just need to look at, if an owner is going to object, how high of a risk is this to your association? What is the type of issue that we're talking about? Again, if it's something minor, quote unquote minor, or if it's something that's a bigger issue and you knew about it beforehand, that may be a different question. But I would think that, most times the board knows what's coming, knows what's going to be on the agenda, knows what, they have standing things, standing topics, what's coming up every month. And so it's probably not unreasonable to just send that agenda out with the notice. And again, if something comes up or something's going to change, just be transparent with your membership if at all possible. Valerie, anything you want to add to that?
Yeah, the only other comment I would have is that unless it's extremely time sensitive, if it is a completely new thing, you can always just bump it to the agenda for next month's meeting, right? Not everything that comes up at a board meeting must be voted on at that board meeting, especially if you are following best practices and having regular board meetings. And so in that case, unless it's super, super time sensitive or urgent, you can have your discussion and then bump the actual vote to your next board meeting so that it can be included on the agenda and removes the argument that any owner might have that you failed to give notice of that agenda item. All right, I'm going to move on to our next question. It's a follow-up to a question that we had last week, which was about a virtual message board idea. And the question essentially was, if the board established a virtual message board in order to have discussions in between board meetings, and if owners had access to that message board, would that run afoul of the open meeting requirements that we are all going to be subject to probably January 1st of 2026? Because that provision of the current WSCAI bill is looking for an earlier enforcement date than WSCAI for all in January 1st of 2028. The follow-up question essentially was just clarifying that it wouldn't be real-time communication. It's a text-based system like using WhatsApp, for instance, or an email distribution list, where the board can post and read whatever they want, whenever they want, and owners can read whenever they want as well. And essentially, I think the question is, like, given these clarifications, don't you think this would probably be okay under the open meeting requirements? And I'm going to be the bad guy here and tell you what you don't want to hear, which is that no, I don't think that this is okay. I do not think that this is consistent with the legislative intent. The legislative intent of the open meeting requirements is this: there is value in board discussion and board decisions taking place at open board meetings where owners have the right not just to listen, but also to participate. And I think that that is a key element that is missing in the sort of scenario presented by these questions. The meeting section of the WSCAI trailer bill that's being considered by the legislature right now, and which is likely to pass, does not just say that owners have the right to listen at board meetings. It says that owners have the right to address the board about board or association business. And that owner forum has to happen at the beginning of the meeting before the board discusses and votes on the issues that are on the agenda. There are rules about how long that has to go on and how much time people must be given to talk. I think that it's actually really well balanced the way that the statute or the bill is written. So it's not going to result in, 3-hour owner forums before the board gets to even vote on its agenda items, right? I think it caps it at 15 minutes. But the point behind this was that owners have valuable feedback to give to the board, and it's kind of useless for them to give that feedback to the board after you've already made your decisions on the agenda items that are before the board. So the legislature wants owners to be able to speak to all of the agenda items and the discussion items before the board votes, not after the fact. Virtual working sessions, whether they are in real time or not, with no opportunity for owners to comment, very likely violate the legislative intent. So I don't think that this would pass muster under the new meetings provision that's currently under negotiation and that's likely to take effect on January 1st of next year. I also think part of the answer to this question is that we don't really know. And I think we said this last week, right? This is a new statute that hasn't yet taken effect. It'll take effect next year. We don't know yet exactly how the courts are going to interpret this, but what we can tell you is what the legislative intent is, which is transparency, communication with, and participation from owners. And I don't think a message group on WhatsApp that owners get to just read and not participate in comes anywhere near to what you accomplish at a real-time board meeting. And so, part of my commentary here, I'm gonna embody Ken for a minute here, because one of the things that Ken gets really grumpy about is how often we have people asking us questions trying to circumvent the open meeting requirements. This happens like, if a month goes by with us not getting a question like this about how to get around the open meeting requirements, that's a long time for us to not get a question like that. And people try to reword their questions and change the facts or whatever, because what some people want is for us to say, it's fine, just keep doing what you're doing, it'll be fine, it's fine. But it's not consistent with the statute. It's certainly not consistent with the bill that's currently before the legislature. If you try to keep doing business outside of the observation of open meetings as required by statute, I think you are running the risk that eventually that's going to catch up to you and you're creating liability for your association. So it's a pain. It's a pain. If you're not used to it, it's going to be an adjustment. I would suggest that you start getting used to it now. And by that, I mean, start scheduling a monthly board meeting every single month. Even if your board now meets quarterly and you think it's ridiculous to have a monthly board meeting, establish an annual board meeting schedule, establish a standing agenda, and then send both of those out to your ownership all in one fell swoop so that you don't have to give individual notice of every open board meeting. You've given them notice a year in advance. And then some board meetings might be 20 minutes if you don't have enough stuff to discuss. Other board meetings might take the hour, whatever it is. But get in the habit now of regular board meetings and of containing most of your conversations on substantive issues to those board meetings. I promise with practice, it'll get easier. It's annoying, but it's a reality that we're all going to have to face sooner rather than later. I'm going to be done with that topic for now. We do have some questions in the chat. I'm going to start with the first one, which is, can an association order an owner to remove a tenant who is being repetitively disruptive? I don't know that there's, I mean, probably not, right? I think ordering an owner to do something is an interesting way of wording it, but the answer to this question essentially is that you have to look to your governing documents. Some governing documents do provide authority for an association to either request or require a unit owner to evict a disruptive or problematic tenant if there's repeated violations of the governing documents. But just like other things that are written in governing documents, for example, the association has the right to inspect a unit, right? If your documents say that, does that mean that you can just hire a locksmith to break into a unit and inspect it, even if the owner has repeatedly told you no? No, we're going to tell you need to go get a court order for that. And the same thing is true here. Even if your governing documents do give you the authority to require an owner to remove a problematic, non-compliant tenant, often in reality, what that means is you end up having to go get a court order requiring that eviction. Some documents will also give an association the right to do the eviction itself, essentially to stand in the shoes of the owner and make the eviction happen. So if you're dealing with this in a particular community, you need to send this question to the association attorney so that they can look at the governing documents for that community and tell you what your options are. Do you have any thoughts to add to that one, Lisa?
No, I think also just communication with your owner is useful. Sometimes the owner doesn't know what's going on, and it's possible that tenant could be violating their lease. I mean, there might be other ways to go about, instead of ordering someone to do something, it might be just keeping them in the loop.
Keeping them in the loop. Also, you can fine the unit owner for violations by their tenant. The unit owner is responsible for the behavior of tenants or people that they invite into the community. And as long as you follow your fine process in your documents, as long as you give the correct due process notifications, you can levy fines against the unit for the violations perpetrated by the tenant. Sometimes that can be an effective way of dealing with it. Let's see, we have one other question, which is, we have lots of other questions. I apologize, we did not get to as many of them as we thought we would today. So we will put those in our document for next week. One other question that we have time for: what is the best way to remove a disruptive homeowner during a meeting? That's also a good question. Lisa, do you want to take a stab at this one, or you want me to run with it?
I can start. I know we have had this conversation in our Q&As before. So if we don't give you a full enough answer, feel free to check out the YouTube page and maybe search under disruptive or meeting, something like that, to see if you can find the prior topics. But basically, make sure that your meetings have a pretty straightforward agenda, and that you sort of start the same way every time, that you have someone in charge of the meeting. Maybe you give a spiel about, this is how our meetings are run. This is what's going to be happen. Let me set the expectations for you. If you are disruptive, we will ask you to leave. We will, if it's on Zoom, we will mute you or turn you off or remove you from the room. If it becomes a really big, a bigger problem, you may consider hiring someone to be there, either a security type person or someone. I know that we have, Ken sometimes has been for some associations, is that sort of moderator. I don't know what you'd actually call his role, but
meeting chair, basically.
The chair, and he will sit there and tell someone to leave if they need to leave or to be quiet. But I think, having clear expectations for your owners about what the meeting, we have a time for the owners to talk, and it's now. Your time is done, and now it's time for our board meeting to go. If you're pretty stringent with those things, that can help a lot to keeping your meetings in line. But Valerie, any other thoughts you might have?
I think having a set of rules for conduct during association meetings is a really good idea. And some of this probably depends a little bit on whether we're talking about a board meeting or an association meeting. So we're trying to cover it from both angles here. But I think having a set of rules for appropriate conduct during association meetings is one way to handle it. And I think it depends on how disruptive they're being and how repeatedly disruptive they're being. If we're talking about a board meeting and you can adjourn the meeting to a different location and not invite that owner to observe the rest of the meeting. As Lisa mentioned, if the meeting is happening on Zoom or another platform like this, you can mute them or you can remove them from the meeting if their behavior rises to that level. I would say, though, that the best advice we could give you is to check with your association attorney before you decide how to handle this, because there might be some specific recommendations that they have for you based on, is it a board meeting versus is it an association meeting? How repeated is the behavior? What exactly is the behavior? because some behaviors you are free to tackle on your own, and you're not taking a risk by doing that. But other behaviors might rise to the level where, there are situations where associations will call law enforcement because of the threat posed by the behavior in question. So I would say, when it comes down to it, that would be my advice, which would be to check with your association attorney. So we just hit 11 o'clock. So thank you all for joining us today. We will put the rest of the questions in the chat for next week. And if you have any other that come up, email us at info@condolaw.net, but we'll see you guys next week. Bye, everybody.